served until those who are unaffected are as outraged as those who are. A very pleasant good afternoon to all guests, professors, students and teams. I am Ms. Nayan Meerpuri, your Master of Ceremony for the afternoon. It is a matter of immense pride to be here before all of you. On behalf of the institution, I am delighted to offer a gracious welcome to all of you to the inaugural ceremony of 17th KSHAN National Trial and Appellate Moot Court Competition 2022. Now, I would like to request the present dignitaries to mark the commencement of the inaugural ceremony by lighting of the auspicious lamp. Proceeding forward, I would like to ask Pawade to felicitate our Chief Guest, Honourable Justice. Now, I would like to request our General Secretary, Borkar, to felicitate Sonama.
Honourable Justice Shri Z, sir, former judge, Nagpur Bench, respected Dr. Praveen Shrivastav, sir, respected Shri Raisoni Z, respected Director Dr. Ashok Pawade, sir, invited guests, esteemed colleagues, teaching faculties, not teaching support staff, and my dear budding lawyers. On behalf of G.H. Raisoni Law College, Nagpur and G.H. Raisoni University School of Law, KSHAN, I extend my privilege to welcome all the guests, all the dignitaries on the dais. From the inception of this college, the mock trial which we are beginning today is the part and parcel of this practical activity. It has been observed during years that this practice helps students in developing their mock and prose skills and also further enhance their personalities and abilities to work together under leadership. I quote Sean Allen, who stated, "Skill comes from consistent and deliberate practice." Therefore, students are reminded that building a practice of gratitude is the best way. I know to create an optimistic approach towards life. Towards this, we are blessed with great women today. They are among with us to further guide us all, and therefore once again, on behalf of G.H. Raisoni College of Law, Nagpur and G.H. Raisoni University School of Law, KSHAN. Thank you.
Thank you so much, ma'am.
Hello, hello. Hello, mic check. Yes.
Now, I would like to request Ms. Amrita Oak to introduce our director, sir, to all of the participants present.
And a leader adjusts the sails. With the optimism and leadership skills vested in him, I introduce to all of you the director of Raisoni Law College, Nagpur, Dr. Ashok Pawade, sir. Sir is a versatile personality, a renowned teacher, academician, and has enjoyed almost all reputed positions in the field of academics. Significantly, his post as a Dean of Faculty of Law in the Rashtrasant Tukaji Maharaj Nagpur University. He has been the legal advisor to many legal educational institutions and is also associated with tremendous social work. He has worked as a civil judge at Prabhani. He was the head of the Department of Law at Yashwant Mahavidyalaya, Wardha. He had been selected for the lone post of Deputy Legislative Counsel in the Ministry of Law, Government of India. He is the permanent trustee of Maharogi Seva Samiti, Dattapur, Wardha. A hard-working and a zealous person who supports the students with his entire will, I kindly request sir to address the teams and the students present here.
To welcome on the dais Honourable Haq Sahib, former judge of Bombay High Court, and has been a very good friend of mine. Honourable Shrivastav Sahib, who is a member secretary of Biodiversity, Government of India, and committed social worker and environmentalist, I can say. Whenever there is a threat to the environment, is always there. Our principal, Dr. Sona Kumar, my colleagues, dear participants sitting in this class, in this particular audience, people are waiting for this event to come, and those who are participating are not participating from the small villages. The city like Bangalore, Delhi, Pune, Chennai, from all the law colleges, from all these places, are vehemently joined in this particular event. When I look back, when myself and Akshay were practicing, or we were taking the education, we hardly any chance to participate in any event as an advocate. The only our journey started, if here any person had no legacy of advocacy, that was the senior's office. And even in those days, attorney was teaching that junior, that was the position. But days now are suddenly not, absolutely changed today. Syllabus is changed today, and you are exposed to the practice right from your first semester. You have been taken to the courts, you have been you are forming the groups, you are actually giving aids in the form of legal aid to the different centers. So there is an exposure to your talent and your knowledge, and this is the platform. Because many times what happened, ये छोटे गांव का जज भी रहता था ना, तो उसके सामने जाने से डरते थे लोग, खड़े होने के शब्द नहीं निकलता था. मैंने देखा है, ये जो जूनियर था ना, वो बात भी नहीं कर सकता, लेकिन those days have gone today. अच्छी बात यह है आपके जनरेशन की कि आपके पास अच्छा करेज है, जो हमारे पास नहीं था. क्यों है मालूम नहीं है. One of the good reason is that you are good in English. We may not be that much good in our time, that we honestly admit. Secondly, you also have the courage to speak the truth. But when speaking the truth is correct comes now, the entire debate starts again. Whole debate starts from the speaking the truth. My dear students, your commitment as an advocate should always be towards the truth. Yes, you will be very honest to your client, and you give your full assistance, you give your full, the knowledge, and don't give any chance to him anything. But your commitment should always be with the truth. That means you are accountable first of all to you yourself. Now, this platform which I am telling you is the platform giving you the birth for advocacy. Law has always said there is no end. If आज सबसे ज्यादा अर्नर कोई होगा ना पर डे वाला वो एडवोकेट ही है, और झाड़ के नीचे रहने वाला भी एक एडवोकेट ही है जो बेल के लिए तरसता है कि क्लाइंट कब आए। आपको देखना है, आपको चुनना है कि वो झाड़ के नीचे रह के क्लाइंट को बुलाना है कि आगे देखना है। इट इज अप टू यू। और आपका अगर सपना बड़ा है, आपकी अगर उम्मीदें बड़ी है, तो डेफिनेटली आप अपना सपना चुन सकते हैं और रायसोनी वाले को डेफिनेटली चुन सकते हैं, बिल्कुल चुन सकते हैं। सवाल और भी है। सवाल क्या है? हम लीगल एड में काम करते हैं, लीगल एड में काम करते हैं, दौड़ दौड़ जाते हैं। मैंने तो हमेशा लोगों को बोला, अरे जब प्रैक्टिस करते हो, अगर एक वकील ने एवरी ईयर 1000 स्टूडेंट ऑलमोस्ट रजिस्टर्ड इन विदर्भ और मोर देन दैट, और उन्होंने कमिट किया कि भाई मैं एक केस में साल में फुकट करूंगा, पैसे ही नहीं लूंगा उनसे, तो अपने को लीगल एड का काम ही नहीं करना पड़ता। लेकिन हाँ तो बोल लेते हैं, बाद की बात में उनका सीरियसनेस चला जाता है। एक पहली बात होगी। दूसरी बात यह है कि हमको गरीब लोगों की क्यों तो बहुत आती है, कहना तो बहुत आती है, हमें लगता है बेचारे के पास पैसे नहीं है, लेकिन आपके याद में प्रैक्टिस कर से इंसानियत ऐसी मर जाती है कि वो होना नहीं चाहिए। पर्टिकुलरली मेरे स्टूडेंट्स तो बिल्कुल नहीं होना चाहिए। आप में कहीं तो भी एक जगह बना लो अपने दिल में कि नहीं, ये बंदा है, इसके पास पैसे नहीं है, आज नहीं कल मिलेंगे, लेकिन इसके लिए झगड़ना है। वहां बात टूट के आती है, क्योंकि जो आदमी पीड़ित है ना सही मायने में, उसको अच्छा लॉयर कभी मिलता है नहीं। इसलिए नहीं मिलता है कि उसके पॉकेट में पैसे ही नहीं होते। और अगर आप केवल पैसे के लिए प्रैक्टिस करते होंगे ना, तो वो वकील को मैं कभी सैल्यूट ही नहीं करता, कभी नहीं करूंगा। पैसे तो वैसे भी आपको मिलना है, प्रैक्टिस जितने बड़े आप होंगे तो पैसे आपको फॉलो ही करेंगे। लेकिन
जो सिर्फ पैसे के लिए प्रैक्टिस करता है वो वकील है ही नहीं। आप समझते नहीं, ऐसा नहीं है, he is a businessman।
Absolutely, Lordship has absolutely pointed out that जो केवल पैसे के लिए काम करते हैं वकील है ही नहीं। मैं तो उनको दलाल बोलूंगा, उससे भी आगे जाके। You must distinguish between दलाल और वकील। आपको दलाल नहीं बनना है, आपको वकील बनना है। आपको कितनी फी लेनी है हम कभी नहीं बोलेंगे, इट डिपेंड्स ऑन यू। आप चार्ज कर सकते हैं डिपेंडिंग द क्लाइंट, लेकिन ये क्लाइंट है जो टोटली रूइंड है, उससे क्या एक्सपेक्ट करते हैं? वो तो आपके लिए, आपके सर्विसेज के लिए बन रहा है, आपको उनको सर्विस देना है। यहाँ आके अच्छे लूसी लैंग्वेज में आप आपका परफॉर्म करेंगे, तालियां खींचेंगे, बड़े आप वकील हो जाएंगे, आपका नाम भी होगा। लेकिन नाम के साथ अगर आप भी इंसानियत भूलेंगे, इंसानियत सबसे बड़ी अहम है पूरे हमारे लाइफ में। हमारे लाइफ का पूरा जो बेसिक है ना, वो इंसानियत की है। पैसा और इंसानियत अगर दोनों साथ साथ में चलेंगे ना, तो आपका लाइफ ही मीनिंगफुल हो जाएगा, सही में मीनिंगफुल हो जाएगा। मेरा एक्चुअली ये कहने का मुझे कोई कारण भी नहीं था, क्योंकि मुझे लगता है कि मेरे जब भी मुझे मौका मिले कि मेरे स्टूडेंट को मैं बोलूँ, मैं देख नहीं सकता उन लोगों का, क्योंकि कितने अच्छे केसेस होते हैं। मैं जब एडवाइस करता हूँ ना, तो परफॉर्म ही नहीं होता दूसरे एंड से। सिविल केसेस में मोस्ट ऑफ द केसेस क्यों लूज करते मालूम है? केवल वकील की गलती के कारण। मैं आपको एक इंसिडेंट बताता, मेरे मतलब किसी का नाम नहीं लेता। एक सिविल कोर्ट ने गलत ऑर्डर पास किया, वो सिविल सूट एंटरटेन नहीं करना चाहिए था कि बॉम्बे पब्लिक ट्रस्ट एक्ट ने बार किया, उसको सूट एंटर किया, इंजंक्शन दिया, और वो मैनेजर आया और मैनेजर ने वो 15 दिन के अंदर सारा बुरा बजा दिया, वहाँ का सारे ओरिजिनल कागज चुरा लिए, क्या क्या गड़बड़ी करके रख दी। तो ये गलत, यानी कि यू सी एडमिनिस्ट्रेशन ऑफ जस्टिस में एक गलत ऑर्डर भी बहुत बड़ा नुकसान करता है। ड्यूटी एडवोकेट की भी होती है, ड्यूटी जजेस की भी होती है, ड्यूटी लोगों की भी होती है। ये 3-4 ड्यूटी में एडमिनिस्ट्रेशन ऑफ जस्टिस चलता है। अगर जुडिशरी इनहांस होती है, जुडिशरी का रेपुटेशन बढ़ता है, तो आपके कारण बढ़ेगा। जो कॉन्फिडेंस, जो फेथ इंडियन जुडिशरी पे है, अभी भी है। थोड़ी देर के लिए मैं नहीं बोलूंगा कि लॉर्डशिप यहाँ बैठे हैं, हुआ है कुछ इंसिडेंसेस, किसी शेकन हुआ है उसमें हमारा कॉन्फिडेंस, लेकिन हम उसमें से नहीं है। हम उनके पार्टी नहीं बनना चाहते, हम उनके ही पार्टी बनना चाहते हैं जिसके कारण जुडिशरी की जो इमेज है बढ़े। आज इतनी स्ट्रॉन्ग जुडिशरी, आई टेल यू, इंडियन जुडिशरी कंपेयर्ड विद द अमेरिकन जुडिशरी ना, 5 साल की पहले की बात बता रहा हूँ मैं। देयर आर सो मेनी इंस्टेंसेस, यानी कि फंडामेंटल राइट का जूरिस्प्रूडेंस इतना बढ़िया डेवलप किया है, लेकिन कभी कभी लगता है कि केसेस केवल वो चार्ल्स शोबराज की, मेनका गांधी की या और बड़े बड़े इनके ऊपर क्यों आते हैं? ये जो एक रूइंग कलाकार है, यानी कि बेचारा सही में रिलीफ के लिए तड़पता रहता है, उसके बारे में क्यों पीआईएल नहीं होती? और पीआईएल में भी हमने देखे कि जुनाइद पीआईएल कितने हैं, और दलाल वाली बात कर रहा हूँ, फिर से वही कर रहा हूँ कि वहाँ पे ब्लैकमेलिंग करने वाले भी पीआईएल वाले लोग हैं। पीआईएल के नाम पे पहले राइट टू इंफॉर्मेशन का वो दुरुपयोग करते हैं, बाद में पीआईएल का दुरुपयोग करते हैं। लेकिन जजेस लायक जो हक साहब जैसे जजेस करते हैं ना, बराबर देखते हैं, उनके नज़र से छूटता नहीं है और वो रिलीफ बराबर देते हैं। तो एक ऐसा एक ऐसी सिस्टम है हमारे पास, एक जो पूरे सिस्टम, मतलब यहाँ की जो बिगाड़ है हमारे एडमिनिस्ट्रेशन का, उसको करेक्ट कर सकते हैं हम। और इतने अच्छे प्रोफेशन में आप आए हुए हो, एक अच्छा मौका है आज। एक ट्रायल कोर्ट का एक मूट कोर्ट कंपटीशन यहाँ पे है। मूट कोर्ट कंपटीशन 2 प्रकार की होती है, एक ट्रायल कोर्ट की मूट कोर्ट कंपटीशन होती है और दूसरी होती है जो यूजुअली अपन हाई कोर्ट लेवल पे करते हैं। हमने ट्रायल कोर्ट की इसलिए किया है कि ट्रायल कोर्ट में ही आपका जो कस है, मतलब आपका जो टैलेंट है, वो रियली एक्सपोज होता है। अगर आप पूछेंगे, साहब से भी पूछेंगे, तो आपको डेफिनेटली ये बोलेंगे, अगर प्रैक्टिस डिफिकल्ट कहेंगे ना तो लोअर कोर्ट की है। सबसे डिफिकल्ट क्या है कि एविडेंस लेना है। आप जब प्रैक्टिस करोगे ना तो आपके समझ में आएगा हाउ डिफिकल्ट इट इज टू एग्जामिन द विटनेसेस। आर्गुमेंट ऑन द बेसिस ऑफ द डॉक्यूमेंट्स यू कैन मेक इट, आर्गुमेंट ऑन द बेसिस ऑफ द रेडीमेड केस लॉ यू कैन मेक इट, लेकिन केस बनाना बड़ी मुश्किल बात है। और केस तभी बनती है जब एविडेंस आप अच्छी तरह कलेक्ट करते हैं। और जबकि ये पूरे ट्रायल है, क्रिमिनल ट्रायल है, एक रेप की केस है, एक इलिसिट रिलेशनशिप डेवलप की वो लड़की के साथ, उसके बाद उसके एक्सपोज हो गई, उसके बाद 376 का ऑफेंस हो गया। अब उसमें आप उसका स्टेटमेंट देखो, उसके बाद फॉरेंसिक रिपोर्ट देखो, डीएनए की टेस्ट देखो, डॉक्टर का एग्जामिनेशन देखो, ये सारी चीज़ें। और क्रिमिनल लॉ की है कि प्रोबेबिलिटी भी नहीं चलता क्रिमिनल लॉ, जो भी एविडेंस होता आता है वो बियॉन्ड डाउट प्रूव होना चाहिए। और 376 की केस क्यों ना हो, अगर 376 थोड़ा सा उसके लिए अपवाद भी है और स्ट्रिक्टली एविडेंस लॉ वहाँ पे थोड़ा सा ढीला हो जाता है, तो क्यों है उसका भी रीजन आपके पास होना चाहिए। आर्टिकल 21 का उसके साथ क्या रिलेशन है वो भी देखना चाहिए। ये सारी चीज़ें आप एज ए पार्टिसिपेंट देखेंगे, सारी चीज़ें एज ए जो आप आज परफॉर्म करने वाले लोग हैं वो करेंगे। और मुझे पक्का विश्वास है आज का जो नेशनल इवेंट है एक अच्छा, जिस तरह से चल रहा है हमारा, उतनी अच्छी तरह चलेगा और हमारा नाम इससे आगे बढ़ेगा। इस 2 शब्द के साथ मेरे भाषण को मैं पूर्ण विराम देता हूँ। धन्यवाद।
Thank you, sir. Now I call upon Ms. Nayan Mirpuri for introducing Praveen sir to all of us.
Intergenerational equity principle. Dr. Praveen Shrivastav holds the position of an IFS. He is the member secretary of MSBB and PCCF Nagpur. Sir has completed his LLB from Nagpur University. Sir attained his post-graduation in MSc Zoology from Delhi University in 1985. Sir has worked in Department Government of India and UNDP sponsored PGPPM from 2004 to 2006 in Public Policy and Management, and Department of Government of India sponsored MA at TERI University Delhi from 2011 to 2013. Now I would like to request our guest of honors to address us.
Honourable Justice Shri Z Ji, Dr. Ashok Pawade, Dr. Suna Kumar. I really feel privileged to be here amidst you on the event of KSHAN 2022, that is 17th National Trial and Appellate Moot Court Competition. To me, mooting is a judicious blend of art and science. Why do I call it art? Because it needs articulation, which may not be found clearly in books. Why do I call it science? Because you need to understand facts and link them with the law provisions. Also, it calls for some research because you have to buttress your arguments with the existing case laws. Therefore, it has, I think, three dimensions. It has an element of art, it has an element of science, and top of all, it has an element of research. But to me, beyond these three factors, still there is X factor. And this X factor is your instinctive response to a spontaneous query from a judge or from the opposite side counsel, which you may perhaps not anticipate, you may not foresee. It is here comes your real skill to really respond well and effectively to the question and the query. Teamwork, organized and methodical approach to lead all your arguments towards an acceptable conclusion is a very, very unique skill. And I'm sure which can be nurtured by the practice of moot courts alone. Trial court, be it of civil or criminal, I think gives the most insightful learning of CRPC and CPC to the students. Being exhaustive, intricate, and dealing with the law ground facts and application of law to them makes the exercise challenging as well as exciting. Here, intelligence and diligence both count, but surely diligence has lion's share, and it is the sheer diligence which in due course of time helps you to inculcate that intelligence which helps you in future profession. This moot court, I am sure, would pave way to the young budding lawyers to blossom into seasoned and successful professional in years to come. Needless to state, Nagpur is a place which has witnessed legal luminaries like Shri Harish Salveji, our former Chief Justice Shri Sharad Bobreji, Shri Bhushan Gavaiji. Certainly this Nagpur city has got something unique and so many others. Certainly this city has something special, something there in its air and ambience which has helped to produce such brilliant legal minds. And I'm sure some who are sitting here, I'm sure would blossom into very successful and seasoned lawyer in days to come. I think it is very aptly said that bar and bench both contribute to raise the bar of efficiency of justice delivery system amidst all the challenges of soaring pending litigations, under-equipped infrastructure, and uncertain ecosystem of democratic governance. Last but not the least, it is in the conviction of young lawyers that there lies the destiny of future of society, especially when complexity of law is geometrically increasing with increased privatization, globalization, and pressure of sustainable development, and top of all, upsurge among people to see a just, free and fair society in days to come. Once again, I thank the institutions for giving me this opportunity to be amidst you and share some of my ideas with you. I extend my best wishes to all the participants and wish the best may win. Thank you so much.
Thank you, sir. Now I would like to request Ms. Amrita.
Thank you, Ryan. Justice consists not being neutral between right and wrong, but in finding out the right and upholding it whenever found against the wrong. Justice Huck is a visionary in his profession. Sir was born on 17th May 1959 and completed schooling from Holy Cross Convent High School, Akola. Sir graduated with a BSc degree from RLT College of Science, Akola, and LLB from the then Sitabai Arts College of Akola. Sir enrolled as an advocate with the Bar Council of Maharashtra and Goa on 15th January 1985 and started his legal practice at District Court of Akola with his father, Mohammad Azizul Haq sir. Sir shifted to Nagpur in the December month of the year 1985 and joined offices of Advocate Shri Z sir. Sir has also represented the Union of India as Additional Standing Counsel and the Government of Maharashtra as A Panel Counsel. Sir was elevated as an additional judge of the Bombay High Court on 21st June 2013 and then was elevated as a permanent judge at the Bombay High Court in 2014 and finally retired in 2021. I would like to share a very personal experience I had with Sir. A few days ago when I went to invite Sir along with Shwetal Kothari, we were invited to his house so humbly and were greeted as if Sir has been knowing us for years and years. We were very shy at first, I would definitely admit that, but as soon as Sir started talking to us, it did not feel like a justice of the Bombay High Court was talking to mere 4th year law students. It is such a delight to have a person.
I was talking to you as my daughter.
Sir, it is a very huge honor to have you among us today, and now I request you to address us.
And dear friends, respected means the teachers present here and all others are covered by the term dear friends, those on the dais and in the auditorium. A very good afternoon. I would like to share some incidents rather than give some speech, because some of my dear friends sitting at the back chairs have already started yawning, thinking that now this judge will give a very boring speech. So I will avoid giving any sort of speech. I will share some incidents. The first thing I want to share with you is the advice which I received from my father, with whom I started practice. On first day, my father said, as a senior, not as father, प्रैक्टिस में दो चीज हरदम याद रखना. एक, जो पावड़े साहब ऑलरेडी बोल चुके हैं, पैसे के पीछे नहीं जाना. काम करते जाओ, पैसा तुम्हारे पीछे आएगा. दूसरा, never give assurance to your client that he has an excellent case. You may be sure that your client is bound to succeed. There are Supreme Court judgments in his favor, but still never give assurance to your client, because you don't know by the time the case of your client is decided, the law laid down by Supreme Court itself may be overturned by larger bench of Apex Court. So, and if you adhere to these two things and work sincerely, there is no reason why you should not succeed and why you should not be at this place addressing some gathering after 20-25 years. You will be there. I have always enjoyed coming to this program since KSHAN, and prior to that when Moot Court started, I have always been a part of these programs either in this college or Ambedkar College, University College, Jalgaon, Pune. At Pune I have occasion to be a part of the panel for international moot court competition, in which finalists were Bhopal and Kenya, and Kenya succeeded. They were the winners.
Despite the fact that Kenya is backward.
That's what. And when I minutely looked at the team, I felt that the two boys who participated perhaps had occasion to wear blazer for the first time. They were very, very uncomfortable in their blazers. But they were the winners. This program gives, especially when you sit on the panel in the competition, I have experienced so good, so nice arguments, and really some arguments are of such points are raised that it is difficult to even think that such arguments can be made by a seasoned lawyer also. I don't know, some of you might be knowing one budding advocate, Akshaya Shirsagar perhaps. She is practicing with Mr. Anil Mardikar, senior advocate. Her first appearance was before a bench of which I was a part. She started arguing, and typical in the fashion as argued in moot courts. I was sitting as a junior judge. My senior brother got disturbed. He repeatedly told her, please come to the point, please come to the point. Then I told my senior brother, sir, please wait, let me handle her.
Very nice.
I permitted her to argue the way she wanted, and within 3-4 minutes she was able to convince us. Even my senior brother was convinced. Then after we signed the order, he asked me, why you were so confident that she has a good case? She was just leaving that first row after arguing. I called her back. From the dais I asked her, from which college you have studied? She gave the name. Then second question I put to her was, how many moot court competitions you have participated in? She was looking at me, and again asked her, I told her that I know that you have participated in moot courts. I can gather it from the way you were arguing. Then she said yes, she was winner in some moot court competition also. Then I told my senior brother, this is what happens when you interact with the students in such programs. You know their depth. Otherwise you take them as juniors. As Pawade sir said, you are far, far ahead than our generation. You are lucky to have that exposure. In our days, we were not having online facility of online judgments. There were limited number of journals, 3 or 4 journals, which we used to get after 15 days or a month. Now you get the Supreme Court judgments today evening online. That judgments are available to you. So that way you are very lucky, and you should exploit your luck and march ahead so that we can also feel proud of you. As far as practice part is concerned, again I am on the same point as Pawade sir has already said, that difficult practice is in trial court. I will not say it is difficult, I will say it is more challenging. You have to prepare the case after taking instructions from the client. You have to yourself sort out what pleadings you should take and what should be avoided. In trial courts it is very difficult to get the instructions, to get the documents, and to take out, most important, to take out fees from your client. Therefore it is very difficult, but you should practice in trial court for at least 2 years. And it is not that I am saying it just for the sake of saying. My son is a lawyer. I forced him to practice in trial court for 2 years, and now he is practicing in High Court, and he is very happy because the confidence level of a lawyer who practices in trial court is totally different. His foundation is very strong. So if possible, don't directly jump to the High Court or Supreme Court. Have the experience of practicing in trial court. Try to conduct evidence. Try to see that how the documents are exhibited, how they are proved, how they are produced. Now, 2 cases which I have dealt as judge, I would like to share those incidents. In one case, the topic is about on POXO, therefore I am sharing these 2 cases just so that you can have an insight of the act from various angles. An appeal came before us in High Court. Minor girl was sexually abused by her father. Victim's mother lodged complaint against victim's father, means wife lodged complaint against her husband. Victim's mother gave evidence, victim gave evidence on the basis of which accused was convicted. He was sentenced for 5 years. Appeal came before us and application for suspension of sentence, grant of bail came before us. On seeing the facts, I was not inclined to grant bail, because after grant of bail, accused was bound to stay in the same house where victim was residing. I thought that it would not be proper if he remains in jail for 4-5 years. The girl perhaps would get married and there will be no chance of both of them staying in the same house. But the girl and mother of the girl supported the accused. They said bail should be granted, and reason was they were from labor class. They said that he is the only earning member in our family. And after his conviction, there is no one to look after us. We are not able to have meals, and education of younger brother of victim was also over. He was not able to meet the expenses of schooling. We were faced with a very difficult situation. The victim and complainant supported the accused for grant of bail. Now in such situation, what court should do? Yes, any of you? Yes, feel free. Whether bail should be granted or bail should not be granted or some other order should be passed. Yes?
Yes, you are free.
Yes, stand up and say feel free. Any other order?
Sir, there should be some relief given to the victim's family, and the accused should be kept in the jail. Some like that, some orders according.
Monetary relief.
Yes, monetary relief. Because all she lacked was a monetary relief. She was just appealing for the bail of the accused because she wanted relief for her children.
Children, yes.
Yes.
Yes, Pawade sir.
It's very difficult. You see, he is a earning member, right? You rightly pointed out, suppose he has been released on bail, he will be with the family. There is another chance. Hello, suppose the accused is released on bail. He will be there in the family, and in the family in which he already had committed the rape with his own daughter. How he will come, how they will live, that is the one point. Secondly, if this is the situation, after 5 years again he will be come back, that will remain there. That is the second point. Thirdly, suppose he is an earning member, right? He is an earning member. Because he is in jail, his family suffered. So if judiciary cannot from their own fund give the, even can give the directions to the government maintain their family. Family can be maintained only by allowing him to the work. So instead of now, there are two options. What I say, one option that he may be released but may not be allowed to going home, right? He may be asked, he should give the maintenance to per month. Otherwise, suppose he has a good case, lower court may commit because he has come before you in appeal, and he might have better case. And if you don't give the stay to the order, then what is the relief? Suppose order is reversed in future. There is also a chance of reversing the order.
One, yes.
Now,
now appeal itself could have been decided at that stage.
That is the point I am telling. If such matter is before you, dispose the matter then and there. Instead of waiting it, keeping it, decide the matter. Don't keep it for years together. Fix the case for final hearing and decide.
Shrivastav sir.
My understanding is if complainant, the wife herself has withdrawn the basic complaint, right? So basic locus standi of the complaint itself is allowed, number one. That being so, entertainment of the case itself becomes questionable to the best of my understanding. And henceforth, I think bail can be granted with the condition, as rightly he has mentioned, that some conditions would be imposed in terms of undertaking that he will not visit the family or the house, or he may be barred from entering that particular district where the wife and her family is residing. So some sort of undertaking or some sort of restriction on the movement of this gentleman, in view of the fact that complainant itself stands in a way withdrawn from the complainant, the wife. That is my prima facie understanding.
Madam, लेकिन अपने मैडम को जाना.
Sir, if evidences are showing the wrong is committed, then according to me, no bail should be granted at all. because the reason is only he is the earning member. This does not mean that he has a right to sexually abuse a minor child.
But when
Yes.
we consider all these aspects,
Yes, yes, I'm coming on that.
sufferers are the family
The
members.
whole
Yes.
family is suffering.
Yes, but that's what I'm adding. Again, after this also they are suffering. But if he is coming back to home and if the things are again repeated, again where they will be going, that is also to be taken into consideration. And somewhere, now when we talk about the equality and all other aspects by the women, they should stand strong for their own requirements as well. And this plea that we are dependent on only the male section of the society, somewhere now they should understand that part also. And on the basis of that, I am very firm that bail should not be granted.
Yes, stand and say, mic is not required. You have to argue in court.
ये discuss रहते हैं.
सबको सुनना चाहिए. Yes.
Sorry to say, I'm first year student. I can
So
be
what?
totally wrong.
So
But,
what?
so I would suggest that we can appoint a constable for some months or time that he can just take a reading or call him every day to police station to report and just keep an eye on the husband.
So bail can be granted.
If in case it is granted, then
Yes.
in this situation it can be granted.
Yes. Anyone else?
Yeah, but in fact, sir,
Yes.
in fact, there is one more dimension, because this crime he might have perpetrated on his daughter, but potential of this man's committing crime on X, Y, or Z in society, there lies the potential risk, and this is the crime against society. Therefore, bail cannot be granted from that angle.
Yes. Anyone else?
But sir, if it is conclusively proved that the ex-wife is a dependent and cannot
Not ex-wife. Wife.
wife.
Wife and daughter, sons.
are dependents and they cannot.
अच्छा. Online team भी what for us?
Yes. Yes.
Yes, yes.
कर सकते हैं.
हाँ.
Audible?
Yes. Please.
So as we support our sir's argument, I would say that, because if he has committed a crime, he should never be released. But as we know this court at Atmanirbhar Bharat, she should be provided with some sort of, occupation or some sort of work that she can do to earn herself a living, and she can, fulfill the needs of the family instead.
Yes. Sir. Thank you. Anyone else? I don't know whether we were right or wrong, but we passed an order, as Rohan said. There is a provision in CRPC, I think section 357 or 457, which casts an obligation on the government to provide compensation to the victim. It is, I think, called Victim Compensation Fund or something like
Legal
that.
service. अच्छा.
No, not legal service.
नहीं legal बोला कौन?
No, it depends. So relying on that, we passed an order, rejected the bail application, and passed an order directing government to pay some fixed amount to the victim daughter till the accused is released. Till that time, that amount should be paid every month as compensation. That was the order.
Very nice. Just like a maintenance order.
Yes, and there is provision in CRPC, and there are judgments of Apex Court. They are very nice judgments. The Apex Court has said that it is a long time that these provisions are brought on the statute book, but they are not being implemented. They have issued directions to ensure implementation of those provisions. You go through that judgment.
Victims compensation.
Victims compensation, yes. Earlier, such provision was not there. It is by way of an amendment it is brought on this statute. Then other similar case, if you are interested.
Yes, sir.
A minor girl had an affair with a boy who was major. But as they wanted to marry, but as the girl was minor, it was not possible to perform marriage. Relations developed. Girl gave birth to a child. Still she was minor, below 18. Parents of the girl lodged complaint that boy was tried, convicted. He was in jail. His appeal and bail application came before us. There, the mother of girl was minor, so mother represented the girl. She filed an affidavit that they have no objection for grant of bail provided the boy marries the girl. So by the time matter came before us, that which she had attended, she became major. There was an affidavit by mother of the boy that yes, boy is willing to marry the girl. Now, crime was committed. Sexual intercourse with minor, even with consent, is a crime. So, crime was committed, no dispute about it. Child was born when she was minor. My brother just said, how can we pass such an order that if he marries, we will acquit him? I said, we cannot pass such an order acquitting him. Then we will reject the bail application. I said, no, we will keep it pending and we will see if they marry. He said, okay, take your proposal further, work it out amongst yourselves. We passed necessary orders to enable both of them to have meetings in jail. Then joint affidavits came that marriage can be performed. Again my brother said that no, we cannot pass such an order. But I prevailed over him and I said we will grant him bail, but only after marriage is performed. Marriage should be performed in jail. All rights should be performed there, and then we will grant conditional bail that it will be for 1 year, and then after 1 year they will report back to the court, and if court feels it that bail order may be continued. And we kept the appeal pending, and we directed that appeals should be listed in normal course, which normally in high courts happens after 15 to 20 years. So they married, and then report came that they are happily living together. These instances I am pointing out to you to make it clear that criminal law does not mean grant of bail, refusal of bail, conviction, acquittal. These are not the only things. In criminal law also there is how justice should be administered to the victim, to the complainant, to the accused, that can be examined and should be examined. Now, you might have already prepared the matter which you have to argue in moot court, but you can develop further arguments keeping in mind all these aspects. When Shwetal and Amruta came, I said that there are many issues which can be raised in PIS, as Pawade sir suggested. Just that day it clicked to me and I told them that you can do some research and file PIL. Challenging the packaging of products in our market. We have pastes, we have soaps, we have many products which are already packed, and then there is another packaging box. That additional packaging box is not at all required, and in some developed countries which are very sensitive to environmental issues, this I am saying because fortunately we have Mr. Shrivastav with us. Countries which are very sensitive on environmental issues, they don't permit such packaging. If the tube of paste is to be sold, it is not kept in a box, it is just tube. Cosmetics, only tubes, no boxes. And for those boxes, we are paying, consumers are paying. Consumers are charged even for those boxes. And above all, the wastage of natural resources. Lakhs and crores of trees are cut down for this packaging material. So some of you can try such PIL, initially make a representation to the government, to Mr. Shrivastav also, copy to Mr. Shrivastav for necessary action, and then file PIL. There are many such issues. We are not attentive about these things, about drinking water. I don't know what is the position in Nagpur about the treatment plants, STPs. I don't think they are functional. We are not getting safe drinking water also. So these are the things which our budding generation will attend to. We have failed in these things, but we look upon you to ensure that you are not failures as we have been. With this, I complete today's session. Wish you all the best and thank you very much. Pawade sir wants me to declare that the KSHAN program, KSHAN Moot Court, National Moot Court competition is open, but it goes without saying. Wish you all the best. How many teams are participating this time?
12.
All the best to all of you. And fact that you are here shows that you are a winner. All of you are winner. All the best to all of you, and not only for this program but in your future life and profession also. Good day.
Thank you, sir. Finally, for concluding, I would like to ask our General Secretary Mr. Borkar, to deliver the formal vote of thanks.
The most urgent duty is that of returning claims. I deem it a great honor and privilege to propose the vote of thanks on this occasion. I would like to thank our Chief Guest, Honourable Justice Shri Z, for gracing this occasion and event and imbibing us with great zeal and enthusiasm. I extend my most humble gratitude and thanks. Thanks to our guest of honor, Dr. Praveen Shrivastav sir, for gracing the event and giving it a wonderful head start. I thank Dr. Ashok Pawade sir and Dr. Sonakuma ma'am for guiding us throughout the preparation days. Last but not the least, I thank all the Moot Court Association members, students, teaching and non-teaching staff for their valuable inputs. Once again, a huge thank you to all of you. Thank you.
Just one more thing I want to share with you when Mr. Shrivastav is here. It is better to strike when the iron is hot. About 20 years ago, I had gone to Supreme Court to attend some matter. After I finished the matter, there was rush in one particular court. That time we were having green bench. Justice Kuldeep Singh was heading that bench and all environmental matters were before that bench. Court was full, so naturally I also felt that I should sit in that courtroom. Someone was arguing, perhaps he was not a lawyer, he was a subject expert, matter related to environment, cutting of forests for the so-called sustainable development. But those arguments, still I remember, the argument on behalf of government was that, sir, we have cut about 5,000 trees, which normally is the argument even in that Mumbai watershed matter or something like that. We have cut down 5,000 trees, we are planting 1 lakh trees, we are compensating the nature. Those were the arguments and the facts and figures were supplied, judges were convinced. But when that expert started arguing, it was fantastic. He said, you are not compensating the nature. In that area, particular types of trees were growing. You are planting trees of your choice, not the trees which were growing in that particular area. And environment depends not only on the number of trees, the type of trees, and the shrubs which grow in the shade of those trees, the smaller plants which grow near those trees, the birds which come on those trees for the fruits of those trees, the what they call pollination. No, birds transport the grains. What? Pollination. Because those particular types of birds come on those trees, the pollination takes place. So planting 1 lakh trees in place of 5,000 trees is not the solution. I remember this when I was talking to Mr. Shrivastav. So these are the issues which are required to be examined. We are happy that yes, government has cut down 1,000 trees, they are planting 50,000 trees, they are compensating the nature. That is not compensating the nature. So keep all these things in mind because future litigation will be relating to all these aspects only. Thank you.
I'm really so impressed with the remarks of Honourable Justice Shri Z. And let me tell you very frankly, I 100% endorse whatever he has said because One, biodiversity cannot be created by a human being.
Human being, that is the point.
Okay? We call it compensatory afforestation. Okay? Let my statement not be misquoted or misunderstood. But frankly speaking, any person with scientific temper will agree that a forest land cannot be recreated because, as very aptly and very rightly he has put, it is not mere trees. It is sum total of soil, groundwater, surface water, herbs, shrubs, climbers, birds, and so many species put together. Yes, at a point of time, prior to the destruction or felling of the trees, that pre-felling phase cannot be recreated at any point of time later. That is the truth. And I hold no compunctions in conceding to the fact that it is true. We did carry out plantation, Forest Department did carry out plantation. That may have made some marginal impact on the improvement of environment. But having said that, construing that plantation effort as a substitute to compensate fully for biodiversity restoration would not be a well-meaning statement. So I fully agree, and that is the truth of life. And maybe a year from now, I also start practicing with you people. And yes, this shall always be an issue of concern and should be an issue of concern for all of you. Thank you so much.
Thank you, sir.
Thank you, sir. We are at the end of it. Another link has to be joined by the researchers, which has already been provided to the team coordinators. If anybody has any queries, kindly put the queries to the team coordinators and they will be addressed as soon as possible. Thank you.
Thank you so much.
Thank you.
To Team K5. Congratulations, Team K5. Thank you. The second best advocate goes to Team K3, speaker number 2. The marks of the second best advocates, which are not to be announced actually, but I would really like to share those marks because the second best advocate and first best advocate was really hard to decide because there is only a margin of 1 mark. So the second best advocate goes to Team K3, speaker number 2 with the marks 318. The best advocate goes to Team K5, speaker number 2, marks 319. The best memorial goes to Team K1, Rizvi Law College. Thank you all the teams. Now time for prizes of our own students. There are 2 prizes, but there can be only one best witness and the second one is the second best witness. So the second best witness goes to Vaishnavi Gubrel. Congratulations, Vaishnavi. Your prize will reach out to you. And the best witness goes to, any guesses? Any guesses? Best witness? Okay, fine. Wow. Okay, so best witness goes to Rosa Sheikh. Congratulations, Rosa. Your prize will reach out to you shortly. Congrats. Someone please hand over a water bottle to her. she is not in her senses. Thank you everyone, and I would really ask everyone to not leave the premises as one more major event is yet to happen. Everyone knows what that event is, and I would really like all the students to be part of our carnival. And without the carnival, our moot court is incomplete, as everyone knows. So I would really request everyone to join us in the carnival event. Thank you.
Guys, please be seated for a minute.
Guys, please remain seated. We still have some announcements. A few days ago, we had a poster making competition on the topic of gender equality, which was on 15th March. And here are the results for the same. So the first winner, that is the winner we have, is Aditi Sinha, Tushar Keshia, Deoni Dohakar. And I request Swati ma'am to present all of the prizes for the same.
Upon her by this constitution. She is trying to incriminate a man for a crime that he has never ever committed. With the permission of the bench, the council would now like to talk about issue number 1, that is a jurisdiction. Much obliged. The jurisdiction of High Court under Article 226 can be invoked, and in the present case, as per Section 374 of Code of Criminal Procedure, the person convicted in a trial held by a sessions judge sentenced him to imprisonment for more than 7 years, and judgment has been passed against him. Hence, he has made an appeal to this Honourable High Court. Proceeding with issue number 2. Your Lordships, this issue is going to talk about whether the accused was consented by the informant. Your Lordships, Vineet was a humble man. He was a gentleman. He always thought of helping everyone. He not only helped the prosecutors, he also helped Mahit Kaur, their mutual friend, with all queries she also had related to the admission process and other things. Your Lordships, Vineet has always been a good person. He has respected the victim, the prosecutors, throughout their relationship, and he has also respected other women in his life. Your Lordships, the consent on the night of 6 December 2021 was freely and voluntarily given. There are no injuries on the victim who claims that she was raped. There are no injuries to prove that she was raped. There are no injuries on her body. There are no marks. There are no abrasions of any kind. And there have been multiple lapses on the account of the investigating officer. The investigating officer, no father's testimony was recorded. There's absence of mens rea here, Your Lordships. On the day of the incident, no neighbors or anything, no cameras captured anything. No one heard the victim shout or yell or resist as she claims. And there has also been an undue delay in filing an FIR against the accused. No justification, no probable justification has been provided for the same. The victim, only evidence that the prosecutrix has is her testimony, which is not totally reliable, and which is also not unblemished. Your Lordships, the accused in this case had no prior information about the victim's father or her legal guardian not being in the house at that time. He absolutely had no knowledge of this. He found out about it only when the prosecutrix told him that this was the case. And the prosecutrix also had consulted their mutual friend Mahit Kaur about contraception. She had talked with Mahit Kaur about different contraceptives, and she was asking for this information. This only indicates that she indeed wanted to take their relationship to the next level. She wanted to explore a physical capability of a physical relationship with the accused, and this is the only reason. This is the only explanation for asking of the contraceptives. And even after that, it is mentioned that the victim was forced to file an FIR by her father. So this FIR that she has filed, it was under pressure. It was under pressure, and it was under force. It wasn't filed by the prosecutrix on her own, and it is not a completely improbable possibility that if she never got pregnant due to the sexual intercourse, she wouldn't even have filed the FIR. The entire reason that she has filed a FIR and she's trying to convict an innocent man for a crime he did not commit is because she got pregnant. Had she not been pregnant, the question of this FIR would not have arisen at all, Your Worships.
What is the evidence on the record about age determination? Because your consent is immaterial if she is proved to be underage, isn't it?
Yes, Your Lordship. Your Lordship, the birth certificate has no veracity. There was no stamp, there was no seal, there was no signature of any authority. The investigating officer did not check the veracity of this birth certificate. He consulted no issuer of the certificate. No municipal authorities were consulted. He directly admitted the certificate. How is it going to be admissible if it hadn't been verified? On top of that, no other age determination test was conducted by the investigating officer. He did not, even after the victim complained that she was raped, no medical examinations of any sorts were conducted on her. No medical examiner was consulted. Even when the victim was filing the complaint, there was absence of any woman officer, which is crucial when rape victims are lodging an FIR. It is crucial to lodge it under the presence of a female officer. All of these lapses in investigation, why should the lapses in investigation part of the IO be the reason why the accused pays for it?
You see, the provisions are for the benefit of the victim. And have you seen the judgment which says that an accused cannot derive any benefit if there was no lady police officer or similar provision was not contacted? It is not for the benefit of the accused.
I recognize that, but that is what leads me to this point that there have been several. This is not just the lab that has been on the part of the investigating officer. All other important procedures have not been thoroughly followed, which is why the investigation is full of is on immaterial grounds. Since there is no complete chain of events in the investigation, there are several factors that have been attacked previously.
According to you, what are the facts which according to you, which are the factors which shows this is consensual intercourse between the accused and the complainant?
No one from around her heard any sorts of screams or shouting that she said that she resisted it. When you're resisting something, you put up a fight, you yell or you shout. But no neighbors, no one ever heard of it. There are no grounds to convict the accused. There are no grounds to prove that it was not consensual. The burden of proof here is lying on the prosecution side.
So you are admitting the incident, but according to you, it was consensual.
Yes, Your Worship. Indeed. The incident of 6 December 2021 definitely took place, but it was not rape. It was consensual sexual intercourse between two people in a relationship.
So according to you, she was not a child within the meaning of section 21D.
She was not a child. She was an adult with complete knowledge of what she was doing. She's capable of making decisions, and she made one. She's trying to claim the blame and pin the entire blame on the accused. She's taking advantage of his good nature.
So according to you, which are the factors which leads the court to disbelieve the testimony of the victim?
As I mentioned before, she said to have resisted the act, but there are no evidences, there are no injuries on her body or abrasions on her body to prove the same. After even keeping that aside, she filed the FIR late. There is a delay in filing an FIR, and a proper justification for that has not been provided at any point during the entire course of investigation. She herself admitted that her father forced her to lodge an FIR. So if her father had never talked to her about this, then probably she would have never filed this FIR. It was filed by her under pressure from her father. Your Lordship, are there any other questions you would like the counsel to answer?
So according to you, why this birth certificate?
It was not conducted by the investigating officer. There have been so many lapses in the investigation that the entire procedure has been taken, Your Lordship.
Which is that provision which gives a presumptive value to the birth certificate.
I beg your pardon, Your Lordship.
Which is the provision of law which gives a presumptive value to the birth certificate. That ordinarily which evidence will have priority. What is that order?
According to Supreme Court judgment, under the POCSO Act, the age of the victim is to be determined in a similar way when the age of a convict in the case of Juvenile Justice Act is determined.
Do you recollect the judgment?
Your Lordship, you are not audible.
Do you recollect the judgment? Can you remember which judgment was it?
If I could just take a moment to recollect.
Doesn't matter.
Your Lordship, it was Gangadhar Tagme versus Govind Agnotri, 2004.
Have you gone through Exhibit 9 of this compilation? So this WhatsApp chat has been released in the form of document. So this document, which kind of evidence would this be? This document, is it oral evidence, documentary evidence, or?
It is an electronic evidence.
Yes. So, which is the provision under the Evidence Act, under which the Act gives procedure for proving the evidence, these electronic evidence?
Your Lordship, in order to admit electronic evidence into the court, a certificate of 65B under the provision of Indian Evidence Act has to be submitted to the court, which has already been submitted by the appealant side.
Which is the recent judgment on this 65B? Are you aware? Recent means which is the landmark judgment on this point?
The council would collectively like to approach the bench as Your Lordships. Hello, am I audible? Hello.
Please go ahead.
Yes. Thank you, Lordship. So I'd like to contest some points that maybe my counsel might have missed on. So to begin with, let's let me just give a short, crisp summary of the date of the incident. What happened that night was the victim, with the knowledge that the father not being at home, decided to go to the party, which is not wrong. She went to the party, which was not wrong. She asked her boyfriend to drop her at home, which was also not wrong. She asked him to come inside the home, which was not wrong. She consented for the sex, that was not wrong. But what was wrong is finding a rape charge against him in the forceful nature. I'll prove it with the stringent contradictions that are recorded. To begin with, your lordships, there are a lot of lapses in the entire investigation, like the co-counsel mentioned. The presence of no female officer, no due procedure linked to 53A of the CRPC, where medical tests should have been done and conducted. The samples, coming to the samples which were taken for the DNA on 10th January 2021, as mentioned, after the arrest of beneath the accused, the samples were taken as stated by the investigation officer in this case. The question is, if the samples were taken on 10th of January, where were the samples for almost 30 to 45 days? There is no report of that. The samples taken on 10th January. The samples reached to the laboratory on 15th, and it contains 3 vials, one of the fetus, one of the victims, and one of the accused. The sample, first of all, reaches. There is no mention where these samples were during this brief amount of time. There are 2 ways the samples are preserved, your lordship. Currently, the technology is evolved only enough so that the samples might be frozen in minus 40 degrees Celsius, and they can be preserved for almost 30 days then. As mentioned in the DNA report, that the samples were mixed with EDTA, which is a solution which is mixed to prevent it from contamination, which can be kept for almost 48 hours to stop it from rotting the blood. Admitting to all the facts, the DNA test was conducted and it came in conclusive of the accused being the father. We are not denying that there was no sexual intercourse that night. Definitely there was, and it was a consensual one. Bringing to the court's attention, your lordships, whenever any DNA test is conducted, first of all, the consent of the victim is necessary.
Mr. Counsel, you're not in the dock for being a father. Once you admit sexual intercourse, we did not be detained by that DNA aspect, isn't it? Being a father is not the crime.
That's absolutely true. That the victim was not minor, but a major, and was capable of giving consent at that point of time.
That is the only issue. Because you are admitting sexual intercourse. If she is a minor.
To proceed, yes, Your Lord. To proceed, I am coming on to my second point. The point is, if there were any samples taken on 10th of January, and it is coming of conclusive of the accused being the father, is not possible. The reason being, it has been proven scientifically. We have scientific judgments that we would like to showcase through our compendium. But there are these journals which say that the fetus can only be, the only DNA extraction can be done after the fetus is 8 weeks old, which in this case was only merely 4 to 5 weeks old. And if the DNA report
we have not made ourselves clear. Your crime is not that you impregnated the victim. So this DNA aspect is absolutely irrelevant because you are admitting to sex. That she conceived is immaterial, isn't it? In this context, were you to deny sex, that would be one evidence on the basis of which the court would have drawn appropriate conclusion. So the small window which you have is to show one, that there was no sex at all, or that she was not a minor and therefore it was a valid consent in law. DNA is immaterial.
The next thing that I am coming to, that the victim was of the age 18 at the time of commencement of the alleged rape, because the victim was born in the year 2003 according to the birth certificate. The veracity of birth certificate is not yet proven, there are no stamp signed. There are a lot of arguments to proceed with that. I'd like my researcher to produce a compendium, a document that we created by reverse aging the entire thing and to prove it to you that how it is not possible according to, in this particular story, that the victim has repeated 12 standards, Your Lordship. No person at the age of 18, we'll come to the document and then I'll proceed with the certain things. But while the scrutinization of documents, the accused came across this fact that she was in fact a major. Yes. Second point is, she has repeated the 12, which has been acknowledged by the prosecution in their memo submissions and other documents. Coming forth, a person who is born in the year 2003 must complete their, yes, Your Lordship.
Go ahead.
Well, also this particular sheet is in front of you. If it is visible to you, please let us know so that we can proceed with the further arguments. Lordships?
Yes, go ahead.
Yes, Your Lordships. So in this particular case, you can see on the left hand side there is years mentioned, the calendar years. On the second hand side there is age mentioned, and third is education, and the fourth is academic year, which goes on in India. To go from the theory of prosecution stating that the birth happened in 2003. So as you can see, Your Lordship, the victim turns 1 year of age in the year 2004. She turns 2, and so forth. It's all in a sequence. If you would like to scroll it down further, yes, Your Lordship. We come to the year 2018, where the victim is giving her 10th standard, and the academic year for the said year is 2018 and 2019. For 11, she becomes 16-year-old. She goes, the academic year is 2019.
This is all your speculation. It has no basis whatsoever in law.
She has repeated her 12th standard to testimony and from the prosecution side. What we are trying to prove here is a person who is repeating the 12th standard 2 times cannot be of 17 years of age according to statutes and the age limits given by the CBSE boards or the Maharashtra board. And this has been calculated from the evidences from the year and rules from 2003. It is clearly stating that the age of the victim could not be 70 at that time because she had repeated the 12th standard. The academic year, if she has repeated the 12th standard, her academic year should have been finished in 2022, which is the current year. She is already in degree college. It has been mentioned in the entire fact that she has completed. She is in a degree college. The only way she can be in a degree college if she was born in the year 2002. In no other circumstances or way, even if you skip the ranks by scholarship, even then it's calculated, Your Lordship. There is no way whatsoever to repeat your 12th standard and still be of that age. This is what we are trying to prove. Neither is the birth certificate, neither is the age veracity test. But also there are conclusive theories that she asked of contraceptive pills that night. She took the contraceptive pills that night, those failed. Leading to the pregnancy, she didn't even want to report the crime at the first place. She was forced into it. She had faith in him. That's why she let him inside the house. This document, particular sheet right now in front of yours, is a clear evidence of there is no possible way. If someone is repeating their 12th standard, it's a clear-cut conclusive evidence that she was born in the year 2002, making her age 18 years old at the commission of the crime, and on 20th of December 2021, she didn't turn 18, but she turned 19. There is no other way to test, but this is through the testimony, through the witnesses which we have then cultivated. We went in a reverse formula. If there was any way it was possible, there is no other verification method. The IO has already lapsed the investigation on multiple grounds. It's Fox and Quality. This is the only way to establish a ground. There is no ossification test to prove the age. There is not 53A to determine the age. There is no father's testimony in this said case, which can be taken as a gravity. It can change the gravity of the matter. Same is missing. But 12th standard documents, she was in degree college. Even the living certificates were relied upon according to Supreme Court judgment, which were not true. There is no document whatsoever. This also brings me to my other point, which was that she was pregnant.
Mr. Counsel,
which happened on 6th December, but that was on multiple instances they had sexual intercourse. Which is proved by the DNA particle.
Can you broadly summarize your grounds, main grounds of challenge? Broadly, you summarize the grounds and then you make your detailed submission so that we will be in a position to understand you more clearly.
Much obliged, Your Lordship. So, to conclude, Your Lordship, the age of the victim was 18 at the time of the event. She was supposed to turn 19. She was 18 and 11 months and 6 days old when the event occurred. Hence, she consented to this. There was no body injury. The FIR was filed late. This leads up to a direction. She took contraceptive pills. It's mentioned. She asked for contraceptive pills on the same day of the said event, which leads us to a matter. She was capable of giving the consent in the said matter. She gave the consent in the said matter. Upon realizing she is pregnant, did the father took her to force her to file an FIR? Only then all of these things came into the limelight. She didn't wanted to file the FIR too. She wanted to abort the fetus, but the father, being a religious man, did not let her do so. She had already wasted 1 year of her education, which was very crucial. She could not let another year go to waste after the pregnancy. The stigma that is going to linger around her. In so, she took the steps by filing an FIR, coming into the court's account, and falsely accusing Vinny for the said matter. After the presumption, victim had all of the knowledge of all of the incidents. She knew the father was not going to be at home. The WhatsApp chats are clear indication they were in love. There is no way. There were quarrels, but there were minute quarrels which have not been brought up. Everything was going fine. The relationship was fine. She consented to the sexual activity provided that she was 19 years of age, 18 years, 11 months, and so forth. That will be all, Your Lordship.
In support of your submission, are you supported by any judgments?
Consulted my researcher for the same as they have compiled it to in a proper manner. If you may permit us, sometime we'll get back to you on this one. Just a minute, Your Lordships, I have here the judgment Harendra Narayan Singh versus the state of Bihar, where it was given at criminal trial the benefit of doubt where two reasonable possible views exist in the circumstances. The court should adopt the view in the favor of the accused innocent. There are multiple cases that we have on our hand right now. Your Lordships, there have been many inconsistencies with the investigation. In Ankush Maruti Shinde versus the state of Maharashtra, a 3-judge bench ruled that serious defects on the part of investigation agency affecting a fair investigation and fair trial amounts to violation of fundamental rights of the accused under Articles 20 and 21 of the Indian Constitution. That there is clear infringement of the rights of the alleged accused. There is also a case of Prakash Chandra versus the state of Himachal Pradesh, where the FIR filed within 7 months after the commission of rape, which affected the possibility of medical examination. In this case, the testimony of the prosecutrix was not corroborated by the witness either. The Supreme Court set aside the conviction and the accused based on the testimony of the prosecutrix.
According to you, which are the facts which shows that the victim had consented for the sexual intercourse? In one line.
And she could consent, she could give her own consent. That is, she had her faith. She had faith in her boyfriend, that's all. Faith is enough. For sure.
Also, Your Lordship, I'm sorry to interrupt like this, but to answer your question from before, in Anwar versus Bashir, it was held that Section 65B is a complete code in itself for its admissibility of electronic evidence and should not be affected by other provisions of this evidence.
Is it thereafter approved or held to be not good law by subsequent judgment of larger bench?
Your Lordship, it was held.
Which is the judgment of larger bench on the issue? than previous.
No, Doctor, I'm not aware of that. I will get back to you as soon as I find out.
It's alright, it's alright.
Yes, please go ahead. Who appears for the respondent now? You are. Amit, but then.
But she's not audible.
Greetings to your Lordship. Greetings, Your Lordship. It is a matter of great pride and honor to appear in front of this honorable court. My co-counsel and I will be representing the state in the matter of Vineet Mehta versus the state of Maharashtra. It is often said, be happy for this moment is your life. That's it, Your Lordship. A moment is all that it took to close the curtains on my client's life, all because of some petty juvenile animosity. But make no mistakes, Your Lordship, for this wasn't an act by some kid. It was a cold and a brutal rape. At this point, the counsel would like to take the bench to the 6th December 2021. The case before this court presents a tragic scenario, one that has sadly become the reality of our country today. At the tender age of 17, a young girl who has her entire life ahead of her had all her hopes and dreams shattered simply because a young man could not help but give in to lust. At such an age, the prosecutor's senses of security and safety has been shattered. At an age where a girl is supposed to go out to college and explore the world, the prosecutor's sense of safety and security was shattered. These are the facts of the case. The prosecutrix was in a relationship with the accused, Mr. Vineet Mehta. They had a loving and a healthy relationship, which took a deep dark turn on the night of December 6, 2021, when the accused forced the prosecutrix into engaging in sexual intercourse, knowing well that she was a minor. She not only had the capacity to consent, but vehemently opposed the idea of entering into a sexual relationship before marriage. The accused, knowing that she did not want to engage in sexual intercourse, let his lust get the better of him and committed the atrocious crime of rape. Your Lordship, the accused has been charged under relevant sections of IPC and POCSO that the prosecution will prove beyond reasonable doubt. The accused today has been charged under Section 376(2)(j of IPC and Sections 4 and 8 of POCSO Act 2012 that the prosecution will prove right now. The respondent today seeks justice, not only for the atrocious act of rape committed against the prosecutrix, but for all that she has lost, a sense of security, her idea of true love, and most of all, her belief and confidence in herself. The prosecutrix may have been one of many rape victims and survivors whose lives have been destroyed due to such inhumane acts. But today, we hope that she will see the accused paying for his crime, see the face of justice. The counsel shall be taking up issue 1 and the co-counsel will be taking up issue 2 for 20 minutes respectively. The first issue, whether there was an act of sexual intercourse on the night of December 6, 2021. It is humbly submitted that the respondent issue be included in the proceedings and the same shall be proven in a twofold manner. Firstly, sexual intent on the part of the appellant. Secondly, penetrative sexual intercourse. And third of all, the respondent was a minor. Beginning with the first sub-issue at hand, whether there was sexual intent on the part of the appellant. Sexual intent precedes desire. Intent essentially is a state of mind of a person willing to do certain actions. In this case, it is contended that the accused had the sexual intent which is evident through his actions. The bench in Attorney General of India versus Satish, comprising of Lalit, Ajay Rastogi and Bella M. Trivedi, stated that the most important ingredient for constituting the offence of sexual assault is sexual intent. Let's start from the scratch with a very basic fact. There needs to be consent from both the parties for getting into intimate sexual intercourse. For consent, one needs to have clear and free communication with their partner. What constitutes the basic components for consent? According to a medical health report, starting with the comprehension of the relevant information by a party, one must have the capacity to consent at the moment. Disclosure of alternative procedures must be thought of by the party, and lastly, one must voluntarily grant consent without pressure or force. It is contended today to court that there were no such components present on the part of my client. It is put before this honourable court that the appellant's pattern of sexual overtures throughout the relationship, despite the respondent's discomfort and is coming on inside of her house and having a conversation because her father was out of town, demonstrates the appellant's intent to engage in sexual relations. This fault, however, was solely on the appellant's side. In this instance, it is evident from the appellant, the respondent, and the witness testimonies that the appellant wished to take their relationship to the next level. Proceeding to the second sub-issue at hand, penetrative sexual assault on the night of 6 December 2021. To establish penetration, it must be demonstrated some part of the appellant's virile member was within the labia of women's utensil, no matter how small. It makes no difference how far inside a woman's body a man's private part enters. On the day of the appearance, December 6, 2021, the respondent went to a party with the appellant and their mutual friend, Mahit Kaur. After the party, the respondent invited the appellant into her home because her father was not at home at that time. Under the guise of discussing a break in their relationship, she put focus on her future. The appellant became furious out of nowhere, overpowered the respondent and compelled her to participate in sexual intercourse. It was rape, Your Lordship. The evidence for the said sexual intercourse is very clear, in which case it may not matter what the accused assume of the situation. This contention can be proved by the fetal DNA report provided in Exhibit 6 of the Moot problem, according to which the DNA of the unborn fetus matches of the appellant. The probability according to the report that the appellant is the father by 99.9999%. This conclusively proves that the appellant is biological father of the unborn fetus. This proves that there was sexual intercourse on the night of 6 December 2021, Your Lordship. Proceeding to the last sub-issue at hand, before my co-counsel moves on, the prosecutrix was a minor. As per the prosecutrix age birth certificate provided to us in Exhibit 5 of the Moot problem, her age at the day of the incident was 17 years, 11 months and 15 days old, which entitles her to protection under POCSO Act 2012. There was an act of penetrative sexual intercourse with the incapability of the prosecutrix to consent. Thus, the appellant is also guilty for the penetrative sexual assault against a minor under Section 8 of the POCSO Act. With this, I come to the end of the first issue, and my co-counsel will be taking up the second and the third.
See, how can the medical birth certificate be considered at all? We have not found even a single statement in your evidence, in the evidence of your victim, that her date of birth is such and such. Has anybody been examined? How does the date of birth come on the record?
Your Lordship, could you please repeat your question? I'm sorry.
We are asking you, how does the date of birth come on record at all? Who says that the date of birth is 20th December 2003? Does the victim say so?
It is provided in one of the exhibits given in the Moot problem, Exhibit 5.
What is exhibit 5?
Here it's the birth certificate of Shreya Gupta.
We are asking you, apart from the birth certificate, does any witness say, including the victim, that the date of birth is 20th December 2003? Victim, her father, mother. Then what is the probative value of the birth certificate or the probative weight?
I understand your question. If you may allow, my co-counsel will be taking out the relevancy of the birth certificate in her issue to prove the point. Thank you.
Greetings, Your Lordship. Am I clearly audible?
You are. Please go ahead.
Greetings, Your Lordship. I will be, as the second counsel for the respondent, I will be covering the second issue, which is whether the respondent had the legal capacity to consent or not. What is established is that to prove the crime of rape, there are two essentials. One, the existence of penetrative sexual assault, and the second being that there is no consent. Penetrative sexual assault has already been taken up by my co-counsel, and therefore I will be focusing on lack of consent. The first issue that we're going to be taking up is that a minor's consent is no consent at all. While we agree with the bench that there is nothing other than the birth certificate verifying the date of birth of the prosecutrix, I would like to point out that the appellant counsel was very quick to contest the birth certificate. But they do not provide any legal backing, any law, any text, any document as to what all should be there in the birth certificate. They have not provided any such information. Therefore, the respondent counsel contends before this court that this birth certificate be admitted as admissible evidence. Moving forward, a minor's consent is no consent.
What we are trying to tell you is that there is a difference between a piece of evidence being admissible and the probative value weight of the evidence. We take it for the moment that the birth certificate is admissible. We are asking you, in the absence of a oral testimony, what is the probative value? Can somebody be convicted on the basis of a birth certificate if the victim does not say that she is a minor? If you have not examined the father, the mother, if the school record is not there?
Your Lordship provided to us, and it was not in our control to go out and get it. Secondly, as far as the mother of the prosecutrix is concerned, she had passed away a while before this incident had taken place. Therefore, as there is no there's no means for us to get it, we rely on what was given to us to build our case upon, which is the birth certificate. Your Lordship, if you may permit, may I move forward with the arguments?
Can you use Exhibit 9? How can you explain Exhibit 9? According to you, Exhibit 9 is proved in the facts of the case or not?
Your Lordship, Exhibit 9 is a WhatsApp conversation taken from one day. We do not know the detailed context of it, and one day's 7 to 10 texts do not speak to the actual state of the relationship.
Before that, according to you, Exhibit 9 is proved or not?
Your Lordship, I don't understand what you mean to say by proof. Do you mind going over the question again?
Means the evidence which is there on the record, is there any statement which proves Exhibit 9, or is it proved by following procedure under 65B?
Yes, Your Lordship, it is. The WhatsApp chats are there, and yes, they are substantiated by the statements of the prosecutrix, the accused, as well as the mutual friend, Mahit Kaur, that they were in a positive and loving relationship. However, the existence of a positive and loving relationship does not warrant having a sexual aspect to that relationship, nor does it undercut the right to say no to any sexual aspects or advances within the relationship.
So, according to you, is there any statement in the material on record which proves the ingredients of 65B or not? That is the pointed question.
Your Lordship, I'm afraid I cannot answer that question, but if you would permit me some time to get back to you, I most definitely will.
You can go through 65B and you can come prepared, no issue.
Yes, Your Lordship. In the meantime, do I have permission to move forward with the argument?
Yes.
Yes.
Like I was previously stating, Your Lordship, in the case of State versus Ishtar Ahmed, a Chandigarh Special Court Judge, Justice Shalini Nagpal, held that having a love affair with the prosecutrix and having conversations with her would not give a license to the accused to commit rape on her person or even have sexual intercourse with her, as the consent of a child to penetrative sexual intercourse is immaterial. I would like to point out that this is not the only case which establishes very firmly that a minor has no consent at all. If you would, I would mention a few cases which have established this. The Independent Thought versus the Union of India, the very first paragraph of that judgment states that minor has no consent. The state of Rajasthan versus Noor Khan, Guru Charan Singh versus the state of Haryana, Virendra Singh versus the state of Haryana, Pierre Mohammed Ghotu Mohammed Ismail versus the state of Maharashtra are among the few judgments which clearly lay down that a minor has no capacity to consent whatsoever. Furthermore, being a minor, she could be expected to be indecisive and could not refuse to the advances of the accused and the advances which took place on the night of 6th December, in which case whatever quote consent she may have had, as the appellant is alleging, cannot be considered valid. This was laid down in Amit Patil versus the state of Maharashtra. Furthermore, it is not always necessary that the testimony of the victim be corroborated by other evidence before the appellant can be convicted, as was held in Rafiq versus the state of Uttar Pradesh. Now, the appellant counsel spoke about the DNA reports and the birth certificates, but the core issue is that we cannot make large assumptions about issues that we were not told about in the Moot proposition. There is no reasonable ground for assuming whether the procedure of collecting the DNA samples and getting the report was entirely correct or not, as it is not mentioned. And in the opinion of the respondent counsel, making any such assumption would be a gross and unreasonable one. Moving forward to the second sub-issue, there was no will or desire on the part of the respondent to enter into sexual relations. As a general rule, if the victim's evidence is free of any fundamental flaws, it does not render it untrustworthy and there is no need to demand corroboration except for medical evidence, as has been laid down in Bharva Bhogivini Hirajbai versus the state of Gujarat in the year 1983. There is nothing that has been stated so far which would suggest a fundamental flaw in any evidence given by the victim, and as far as the medical evidence is concerned, that is corroborated by the DNA fetal report, which exclusively proves Vineet Mehta to be the father of the unborn baby. The statement of their mutual friend Mahit Kaur as in Exhibit 8 cannot speak to what the true intentions of the respondent were. It has been brought up in this court that the respondent and her friend Mahit Kaur had conversations about taking their relationship to the next level and about contraceptives. However, it does not mean that Mahit Kaur can speak to what the intentions of the prosecutrix were. Furthermore, she is a 17-year-old girl who has recently lost her mother. It is very plausible that she might have been curious about contraception and wanted to know for her personal knowledge. Furthermore, it is contended that the phrase taking the relationship to the next level does not necessarily mean physical intimacy. It could mean a lot of things. For instance, it could mean, hypothetically, it could have meant that the prosecutress wanted to tell her father about the relationship. What cannot be overlooked by this court is that at one point of time, the prosecutrix made her feeling about not engaging in sexual relations before marriage absolutely clear. If we would turn to Exhibit 4, the second paragraph, the very last line, the prosecutrix statement states that Tilaki told him that she was not comfortable with sexual overtures and did not want to indulge in a sexual relationship until marriage. Moving forward to the third sub-issue was the mental capacity of the respondent. While the respondent counsel does not accept that the prosecutrix had consented to this act, for the sake of argument, even if we consider it, but it is required that her mental capacity and her maturity level be considered. Ranjit Rajvanshi was the state of Bengal. Paragraph 55 of the judgment requires a mental capacity, requires a maturity level to be analysed by the court before a judgment is passed. This respondent's father doesn't seem to think that she's capable or mature enough to handle a sexual relationship. And the one person who has raised the prosecutrix, his word can have some weight in terms of how much maturity she is perceived to have. The only person who can truly speak to that, of course, is the father, but neither his statement was not taken as part of the Moot proposition, nor was he allowed to be a witness during the sessions trials, this was done as part of the rules and regulations by the institution.
There's some connectivity issue from the speaker 2 side. Can you give us 1 minute, please?
Okay. I can't seem to speak from here. Am I audible, Your Lordship?
You are audible, also not visible.
I apologize for the internet connectivity. If I may be allowed to speak. There have been studies, psychological studies, which prove that the loss of a parent for a young child and repeating a school class puts children under a great deal of stress. These reports have been cited in the memorial submitted on behalf of the respondent. Keeping all of this in mind, if at all any consent was given, it cannot be seen as valid at all. Rape is a crime against the very basic human rights and is violating of the fundamental right to life and must be dealt with sternly and severely, as has been established in the case of Rup Singh versus the state of Uttaranchal, 2006. It has further been stated by Justice Krishna Iyer that while a murderer kills the body, a rapist kills the soul, in the case of Amit Patil versus the state of Maharashtra. Your Lordship, it is very clear that the respondent in this case was a minor. Therefore, the respondent counsel submits before this court that the appellant is guilty under IPC section 376(2)J for raping a girl who had no legal capacity to consent. My co-counsel would move on for the prayer, and when allowed, we would be going forward for our rebuttals.
Lordship, to proceed with the prayer.
Please go ahead.
Hello. Lordship, you're not audible, I'm sorry.
Please continue.
Lordship, in the light of the issues raised today, the arguments advanced and the authorities cited, we request this Honourable Court to please firstly dismiss the appeal, second of all uphold the judgment of Section 4 convicting the accused under Section 376(2)J of the Indian Penal Code 1860 and Sections 4 and 8 of the Protection of Child from Sexual Offences Act 2012, and third and last of all, convict the appellate for charges of rape and sexual assault under Section 376(2)(j) of the IPC, Sections 4 and 8 of POCSO Act 2012, and pass any other order that this Honourable Court may deem fit in the interests of justice, equity and good conscience, and for this the respondent, as in duty bound, shall humbly say. Thank you, Your Lordship, he rests the case.
Your Lordship, therefore, the appellant move towards the prayer. We'd like to get some final closures to everything, if you may permit.
Yes. Yes, go ahead.
Your Lordships, to begin with, I'll, in a quick summed up way, I'll examine all the exhibits. FIR. Not a piece of substantive. The charge sheet locally charged for POCSO, because the only way he charged, the IO was IO charged, then for POCSO, through the birth certificate. Moving on, Exhibit 3, which is the IO statement. The lapses in the investigation, no female officer. Plain ignorance of 53A of CRPC, where medical practitioner who does age verification and medical tests were not conducted. The victim came in reporting the FIR because she found out she was pregnant. The father found out. Reports for this pregnancy never found. Seizures of these blood samples that were taken by the IO never found. No Panchanama, nothing. Next thing, victim statement, exhibit number 4. FIR was post as it is mentioned in the judgment. Page 2 of the judgment. It's written in the point 5. On 10th January, after inquiring about the incident multiple times, the victim's father, by which the age could be verified, the birth certificate is already in question, no stamps, no see nothing. Your Lordship, that when the police went to the accused's house to take the statement and to arrest him, he was very calm, he cooperated with the police. This also leads us into a mindset that he didn't try to abscond or run away. He proceeded and he assisted them with the investigation in being a competent person. He answered the questions perfectly and gave the statements to the police. Moving forward, the defense witness, the next Mahit Paul, which was plain-sightedly ignored, she has clearly mentioned that on the date of the party, the victim asked her about the knowledge of contraceptives, oral contraceptives. And the last, Exhibit 9, WhatsApp chats, the electronic evidence with 65B certificate. These WhatsApp chats, Your Lordship, were not WhatsApp chats but WhatsApp screenshot. A screenshot taken from the victim's phone. And that too of the set date. Nothing prior to it, nothing after it. Which only proves that one particular point. And that too is being refuted. Apart from all these exhibits falling in the defense's favor, I move forward to state that the respondents have nicely put up forth an emotional story based on assumptions before this court. However, if law does not come into the conclusion or assumption, the court relies on admitted facts, circumstances and evidence record. Nothing was brought in the record, nothing to testify the age. And the arguments advanced that the appellants made was sufficient evidence to prove in fact that the victim was not minor, she was a major, and her consent was viable. That's why she was charged. That's why the accused was charged under 376(2)(j), because she was not capable of giving consent. But here she is a major and hence becomes capable of giving consent. Hence, the POCSO Act also is standing on a thin ice, which is not even thin at this point of time. The opposition counsel time and again used the word assault. However, they have been miserably failed to provide any evidence that there was any assault at the first place. There were no corroborations can be taken. There was no scratches, bruises, nothing. No voices from no type of resistance can be seen. No shouting, no screaming, no biting, nothing. The report is lost 1 month later. So even to get the scratch marks, it becomes difficult. The birth certificate. Coming back to the birth certificate has to be registered with the concerned local authority, which issues the certificate. For instance, Delhi, the Municipal Corporation of Delhi and Mumbai, and henceforth. In urban areas, as per the Office of Registrar General and the Census Commissioner India, municipal corporation or municipal council issues the certificate. So where are the stamps? Hence, the seal, stamp and sign and the signatories of the authorities hold a moral ground, hold a lot of evidentiary value in this case. This is a law impediment to follow valid rules which were missing. Hence, the birth certificate is not admissible. Your Lordships, to move forward, the council would like to proceed for the prayers, if you may permit.
Yes, go ahead.
I hope I am visible, Your Lordships.
Yes.
Your Lordships, it is hereinafter most humbly prayed before this Honourable High Court that in the light of the issues raised, the arguments advanced, the authorities cited, it is humbly requested that this Honourable Court may be pleased to declare that the appeal made by the appearance is maintainable. The council seeks for the relief that the Sessions Court judgment should be quashed and set aside. The appellant seeks Honourable High Court's intervention into the matter and seek acquittal. And any other equitable order may be passed on the favour of the appellant. And or pass any other order that deem fit in the interest of justice, equity, and good conscience. For this act of kindness, the petitioner shall always be duty bound and forever paid.
Your Lordship, does the Respondent Council have permission to move forward with the rebuttals?
Yes.
I'm afraid you weren't audible, Your Lordship.
Yes, go ahead.
Before the council starts, can the courtroom officer please let us know how much time we have for that?
15 minutes.
Alright. Your Lordship, the case today here is a very simple one. It is that of a cold and brutal rape. We've gone over the facts of the case, we've gone over the arguments of both sides, and therefore I will get directly to the rebuttal. The appellant mentioned in their opening statement that the prosecutress and the appellant met and their conversation started with college-related information, with the admission procedures. Further, on page 20 of the appellant's memorial, it states that Vineet Mehta had helped the prosecutress with the admission. Yet they claim that he does not know her age. How can somebody who is helping and working on somebody's college admissions, which mandatorily require their age to be written, not know the age? However, even if we take this as a careless attitude on the part of the accused, on the part of the appellant felt no responsibility whatsoever to cross-check the age of the respondent before he got into before he had sexual intercourse with the respondent. The appellant side has spoken about the prosecutress not having any injuries on her body. Let us be very clear here. The courts in the case of Dastagir Saab and another versus the state of Karnataka has iterated that injury on the body of the person of the victim is not a sitting for non to prove the charge of rape, and absence of injuries on the person of the prosecutress would not be sufficient to disregard the prosecution case. Furthermore, in the case of KSHAN versus the state of Haryana, it had been established that physical marks on the body are not required to prove rape. The appellant counsel has talked about how the respondents have made gross assumptions and not admitted facts when that is all that they have done. They have assumed regarding the DNA certificate, they have assumed regarding the procedure of the investigation, all of the information which we were not given, all of the information which is limited to the proposition of this moot court. Coming further, there was a point raised by the appellant counsel that there is no camera recording anywhere that such an incident happened. The counsel for the respondents doesn't feel that usually people have security cameras in their homes to have these things recorded. It is not required that there may be physical resistance, screaming, shouting, screeching for a person to be unwilling to enter into the act of sexual intercourse. Basing their argument on this speaks the very misogynistic approach taken by the appellant, all to score an acquittal. They was spoken about the 1 month delay between the day of the incident and the day of filing the FIR, while completely not taking into account the fact that today we still live in a patriarchal society, and unfortunately incidents such as rape and pregnancies out of wedlock are still covered by shame and stigma. The very same shame and stigma which had then caused the respondent's father to decide that the baby will be given up for adoption. Keeping all of this in mind, the delay of 1 month cannot be enough to refute the case of the prosecution. As I'm sure all of us in this courtroom are aware, there are cases in which these issues have come up years later. The appellate counsel also spoke about Exhibit 9, which was the WhatsApp chats between the prosecutors and the appellant. Chats of 1 day, 10 text messages taken out of context in a vacuum prove nothing. The right time, or a year earlier, or 2 years earlier, therefore assuming her age on the basis of that is completely unreasonable. All of that put together, it is a very simple case that the appellant has put forward. It is a case based on gross assumptions and hardly any facts. We would like to submit before this honourable court that given that our client is a minor, she is entitled to protection of special laws such as POCSO. Those laws were enacted for a reason. Keeping those things in mind, keeping the authorities cited, we pray before this court to convict the appellant on all charges. Thank you very much.
Your Lordships, can the appellant side begin with the server button?
Yes, go ahead.
Your Lordships, the respondent side is very conveniently trying to blame everything on the host college. This is the same information that was provided to each and every team, and we have worked our way.
Which will enable you to succeed in all walks of your life, and therefore you must try to read all the material, all the books, the techniques to enhance your concentration, because it is the concentration which would lead you to success in studies, in your profession, in your life, and in all walks of your lives. Swami Vivekananda, in his various books, has defined education in one word as concentration. So according to him, it is the concentration which is the basis of education, and it is all about the education. The second tip which I would like to give you is to develop your analytical ability, so that studying as an advocate and while arguing the matters before the courts, it is your analytical ability which would help you to prepare the case and to prepare and to argue the case before the court. Because in High Court, when you argue the matter, most of the lawyers come prepared, but when they are faced with a situation in relation to those questions on which they have not prepared, then that time real skill of the advocate which counts, and that differentiates between the successful advocate and the ordinary advocate. It is your ability to think while arguing the matter as regards those points which you have not prepared. That differentiates you from the successful advocate and the advocate who is ordinary advocate. And third thing is you should develop ability to be objective about everything in your life. While studying, you must be objectively study in the light as to what you are going to achieve. Getting marks in examination is only one of the objective, but to improve your personality as a whole, and while developing that personality, your objective thinking really differentiates you from the ordinary advocates who are though prepared while arguing the matters but are not successful. So these are the 3 tips which I could give you within this short time, so that now if you have any questions, I will try my best to answer those to your satisfaction, so that it should not happen that you had something in your mind and that is not addressed by me.
Greetings to the Honourable Bench, Justices. Sir, being a law student, I have this doubt since first year of my college life. This concept of internship has been developed for the past 5 to 6 years, where the chambers have accepted this concept. So I want to know, this concept has been accepted by the bench also. What is the view of the other side of the bench also?
See, about interns, to be frank, at that stage you are too junior to understand the niceties of arguing the matters. As your age progresses, your ability to grasp the facts and the position of law, that goes on increasing. When you are working as an intern with a judge, you gather the facts only. As it has been said that the intelligent person and ordinary person, the ordinary person compiles facts, but it is the intelligent person who gets relevant facts. To distinguish between the relevant facts and the ordinary facts, you have to get experience, and as the experience increases, you know the distinguishing factor between the irrelevant facts and the relevant facts. And once you know what are the relevant facts, accordingly your personality as an advocate goes on increasing. So when you are working as an intern, at that stage you get yourself used to the environment of the court. The court fear factor goes. Those will be the only benefits which you may get, in addition to improvement of your knowledge about the law. That factor is concerned, it is individual capacity of individual student to grasp those facts. So if you are intern, if A person is intern with a judge and B person is intern with different judge, it is not necessary that the experience and the knowledge which A gets would be similar to the knowledge which B gets. So it is your ability how to learn the relevant information and your objectives in your life. So everything depends on that, and the interest which you have, because once you are interested, your passion determines how you remember the facts. So if you are interested in law, then automatic consequence of it is that your personality as a advocate improves. So while working as an intern, you must have passion for the law and passion to become a good advocate, good individual and good human being.
Greetings to the Honourable Justice. Sir, I want to extend this question further. We are generally being told that law in practice and law in books is very different. So, as a student, what should we focus on?
As a student, you must focus on law first, and second priority should be to improve yourself as a person, because this is the tender age where you develop your personality. And if at this age, if you are aware that you are going to become a good advocate and you have a passion for that, then accordingly you will take all the necessary steps like reading, what to read, when to read, all those decisions you will take according to your passion. It is advisable to read the biographies of the legal luminaries which are available in the market and at the libraries. But it is, while as a student, you must first focus on passing the examination, and if the time remains, then you must devote your time to develop you as an advocate in future.
Greetings to the Honourable Justice. So my question is regarding the today's moot problem that we were facing. I had this question since the beginning. So the question is that if person A falls under the definition of child under the POCSO Act, and she indulges in an intercourse with person B, knowing that A is below the age of 18 years, will it be considered as a rape even though it is a consensual intercourse?
Yes, because according to POCSO Act, if you indulge with a sexual intercourse with a child which is defined under 2(1)D, then irrespective of consent, that will be treated as a rape.
So, but the consent was there. So, if A is a female who is under the age of let's say 17 or 17 and a half, like there was in the today's moot problem, who can understand what consent is because of the education level that she or she has got. So then if she understands consent, then will she fall in the category so that she doesn't understand the word consent?
Technically that will be the offence, but while imposing the punishment, the court can take into consideration all these factors.
Okay. Irrespective of the moral character of the accused.
Moral character of the accused will be considered at the time of imposing of punishment. First, court will have to decide whether offence is committed, proved or not. Once the court holds that he is guilty of commission of offence, then while imposing punishment, court will take into consideration all these factors.
Alright, sir. Thank you for that. And also I had a little doubt since I am new to the law teaching and everything. So I wanted to know that what are your views on the age as a criteria for understanding the consent? Like if
at public platform, it is advisable not to comment on this, because we are all bound by the law. So if I have any personal comments on this, I will, but not in a public platform.
Alright, sir. Thank you so much for your answer.
Good evening, sir. My question is on judiciary. Suppose I cleared the preliminary exam of judicial service, then I cleared the mains, and if they will ask me about the experience of 7 years, so how will I prove that I had practiced 7 years in court?
See,
depends on your date of enrollment as a advocate. If there is 7 years gap and you have not suspended your registration as a advocate, then you would be presumed to have practiced as a 7 years as an advocate, unless there is any other material that you were working somewhere on full-time basis or something. So that will be considered from the date of your registration as an advocate. Yes, thank you.
Thank you so much, sir. I'm pretty sure that we're all going to imbibe all the values you've set for us. Moving ahead, we have our Honourable Justice Shri Rohit, a leader, also an achiever, someone who believed in the impact of his vision, a gold medalist and one of the prime toppers. With this, I introduce you all to the Honourable Justice Shri Rohit. Sir, as being a variable, has done civil, constitutional and criminal cases including trials. September 1986, where he initiated a journey of a lawful path. While his workings, he joined chambers of senior advocates, SP Dharmadhikari. He has also been appointed at ASGI 2014. Striding ahead, he has been an AG in 2016 till elevation. Has also been there as an ex-chairman for the Bar Council of Maharashtra SPL Committee. An ardent supporter of skill and talent, I'd like to request sir to please be our guiding light and address our participants and everyone present here today and provide them with a short feedback.
Brother Justice Amit Borkar, Dr. Pawade, Madam Dr. Sona Kumar, and all the faculty, my dear friends. All in good spirits, but my brother has already told you that this has come as a surprise. We had thought that we would judge and depart, and we have a joint engagement. We have a meeting of the National Law University to attend. So there are a few time constraints. Having said that, today was indeed a memorable day. The last time I came probably was in 2017. And I have always loved being a part of the Moot court process. Before I declare or rather we jointly declare the winner, I and brother Borkar had shared the responsibility because of the time constraints. So he was to address you, which he has done, and I'll be declaring the winner within a few moments. You all are aware that Moot court is but one step which was thought would bridge the gap, so to say, between the skill set which a law college institution ordinarily imparts in a student and a skill set which we as judges expect even a junior lawyer to possess. everybody knows the great eminent jurist Fali Nariman has said, the problem is not lack of educational institutions imparting knowledge in law. The problem is of the quality. Quality of the legal education, the fact that a finished product is only equipped with a degree, and the first appearance in the court is a reality check. It does come as a reality check. You realize that counsel pleads ignorance means nothing in the High Court. So, but then, having said that, the moot court competitions do help. They do help in the process of trying to learn new things, trying to be curious about it. Stage fright, surely, as somebody mentioned, I believe Dr. Pawade said, stage fright is one obstacle, the initial obstacle. So maybe you are used to addressing a particular audience. I would have liked if the participants who have attended so many moot court competitions go beyond the problem and think out of the box. For example, in the present facts, I expected somebody to invite our attention to a view taken by the Madras High Court, which a learned single judge of the Madras High Court, who said that I may or may not agree with the results, I surely agree with the sentiments behind it. You see, when the, as we call it, the Cupid came calling, a boy falls in love with a girl and the girl falls in love with the boy, you don't ordinarily ask for her age certificate. So, we can visualize the situation that a girl who is to turn 18 after 2 days willingly, or even say after 24 hours, willingly enters into a physical relationship. As the law stands today, the boy is doomed. It would be a rape. While punishment, I don't know, because there is a minimum punishment, and that minimum punishment itself is very harsh. So the court has no discretion in the matter. It may be treated as a mitigating circumstance, but you are bound to award the minimum punishment. All these aspects of the matter are pretty thought-provoking. We as judges have our limitations, particularly when we act as the appellate court, sitting singly. We are not deciding the constitutional validity of the law. We can only go by the law. Now, such questions should come from Dr. Pawade, Dr. Kumar, from you all. There should be an evolution of thought, whether there can be a middle ground, whether the court should be given the discretion to conclude that, well, she had only maybe, sometimes not even, it could be 12 years before completion of 18 years, 12 hours, not years, 12 hours, maybe before on the birthday eve or something. So, all such questions should naturally arise in your mind. What can be done? What should be done? How it can be done? So, I expected somebody to broach this topic while arguing on this talk show matter. insofar as how you as youngsters should go about it, Brother Borkar has eloquently told you the tips, and like we do in the courtroom, I respectfully agree to add. He has told you what you should be doing. Let me tell you one or two things which you should not be doing, and which I am noticing in the courts from young lawyers. The first thing you are not to do is never ever do your research with the assistance of Google Guruji. I can make out a person with substance and a shallow a person who has only information. You see, what happens is, when you read a commentary, you read a text, you know the legislation, you know its past, you come across several views, then you can go through the entire scheme. One section, one provision in law is never a standalone provision. If you have to understand a provision, you should understand the entire law. You should know what is the object behind the law. What is happening is, as I see it on a day-to-day basis, one word is put in that so-called search engine, then some judgment is retrieved, and then the lawyer keeps on and tells me, most often than not, that is a view which is already overruled in some other subsequent matter. But he is telling me information. He doesn't know the law, and you have to ensure whatever you do, please don't ever go to internet or your Google, for that matter, whatever name it is called, for your research in law. You have a problem, you are faced with any problem, please take out the best possible commentary. You can go to a search engine, maybe some site of some law publication, as a final, just run through it to ensure that you have not missed something. Or sometimes the edition is pretty old, some last edition is of the year 2019, may not have your, the latest case laws. Then you can fill in the gap between 19 to 22 by going to Google or searching for, but that is one thing which you have to avoid. And the second thing which you do, although I have nothing against businessmen, please remember, law is not a business. Law is a profession. And while a businessman would be fully justified in having the end in mind, a lawyer as an officer of the court owes first and the paramount duty to the legal system, the court, and then to the client. Never ever lose a court by making a submission which is either ridiculous or which is already decided by a binding judgment, and never ever make an incorrect statement in the court. Doesn't matter that you lose the case. If you lose the court, it is I don't have to tell you, virtually the end at least of your reputation. There are dishonest people who are prospering, but then that is a systemic fault. You have dishonest people who are ready to respect dishonest people, and the dishonest people therefore prosper. So that apart, I am telling you not what is the utopian state of affairs, but what we can achieve, what we can reasonably hope for. At least two things: be ready, don't ever treat law as a business, and don't ever go to Google Guruji. The rest, if you follow what my respected brother has said, surely you would be in the top echelons of the practice. Thank you so much. And I'm so sorry, I missed that for which, I had shared, yes. The winning team is Symbiosis Pune. Nagpur Kamal Narayan College of Law is the second best. But we have to mention one thing. We had a serious problem, I and brother Borkar, in deciding the winner. Everything was so close, but then both a joint winner was not appropriate, and therefore we have selected this Symbiosis. We didn't know it then, but Symbiosis Pune as the winner. So congratulations to all the participants and thank you.
Thank you so much, sir, for your enlightening word. On this note, I would like to conclude this ceremony for you and ask our President for the Moot Court Association to have his voice on the mic.
First of all, thank you to the Honourable judges who gave their very valuable time to us and agreed to wait for the valedictory rounds. Thank you so much, judges, for your valuable time. Afternoon to one and all present here. All thanks to Almighty for this beautiful day. I, on behalf of Raisoni Law College, thank all of you for coming and remaining with us at this vital event. I am especially thank you to the chief guests for their cordial joining. It really proved encouraging for all of us. I express my gratitude to our esteemed ideals, Shri Raisoni, Chairman Sir, Director Shri Ashok Pawade Sir, and our Principal Dr. Sona Kumar Ma'am for their approval for this moot court. They have assisted us in not just our development but also in enhancing our creativity and our knowledge. And last but not the least, a body is always appreciated when there is a healthy functioning of all the organs together. For us, these organs were our students' committees, which came together and did their respective jobs within the given time and without any flaw. They were always here to assist and advise us in unimaginable ways. They helped us with the development of ideas and the execution of those. And I congratulate all the participants and teams for their intellectual performances and congratulate you for your future endeavors. Thank you all. Have a good day. By this, I would like to conclude this